because when President Trump sent the and mobilized guard units to be sent to the District of Columbia, there was a lawsuit against him to say, no, you can't do that. You've overstepping your bounds. And I'm looking at a decision from the United States Court of Appeals for the District of Columbia Circuit, filed on December 17th, 2025. This is docket number 25-5418. District of Columbia versus Donald J. Trump in his official capacity as President of the United States et al. And the issue here is, can the president mobilize and deploy National Guard troops to the District of Columbia to address violent crime and to ensure public safety? That's how the issue was framed in that case. And the Trump administration cited Title 32 of the United States Code, Section 502, subparagraph F. And what's really interesting in this, when I first looked at it, the number of amicus curiae that were brought into this, who was sought to be brought in, was extensive. And for those of you who don't understand, amicus curiae meaning we're not the plaintiff or defendant here, but we have an interest, we believe, we want to be able to chime in.
Friends of the court, right.
Friends of the court. So they have a lot of people chirping in the ears and filing briefs on this matter. And initially, in the District of Columbia, the district court in the District of Columbia basically said, you know what, we're going to grant the temporary restraining order. And it went up to the Court of Appeals, and the Court of Appeals heard the appeal from the Trump administration asking for what they call a stay of the restraining order to still allow the deployment while the appeals are still going on. And the district court, the appellate court for the circuit of the United States Court of Appeals said, you know what, Trump administration, yeah, we're going to grant you relief, because here in the District of Columbia, unlike the states of the Union, the District of Columbia is not a state, and it doesn't, and there's a lot to unpack with that, but by federal statutes from the time of the founding of this country, the district is just a district, and it's run by the federal government with the executive, the president, running the show. Generally speaking, the Congress has to do, the appropriations and whatever, but the president is able to mobilize the guard and to protect the citizens. So in that case, Trump got his way insofar as being able, while it's on appeal, to still have the guard mobilized, because the court there, the appellate court said, you know what, as a finding, we have to show, or at least believe, a couple of different tests are going to be founded by, or at least cleared by the Trump administration. Among the prongs being the likely success on the appeal. And they said, you know what, likely that they're going to succeed, because based upon the federal statutes, the president has the authority. It's fine.